in legal profession and professional misconduct and professional ethics, one of the most important subject is the relations between war and bench. So in this lecture we would like to discuss the very introductory analysis in relation to war and bench. War and bench are the twin pillars on which the edifice of justice stands. So, any collusion between the two will lead to collapse of administration of justice. As Lord Denning in his classic work, The Discipline of Law, rightly observed that a member of the bar undoubtedly owes a duty to his client and must place before the court all that can fairly and reasonably be submitted on behalf of his client. At the same time, as a member of the bar is an officer of the court and must uphold the dignity and decorum of the court which is paramount. The Supreme Court adhered the views of Lord Denning in the leading case, Lalit Mohan versus Advocate General in 1957, wherein the legal practitioner imputed particularly an unfairness, partiality against the munsif in open court. He suggested that the munsif followed no principles in his order. It was held that the legal practitioner overstepped his limit of propriety and was held to be guilty of this sham. Indian lawyers, instead of opposing the arrival of the foreign professional misconduct, and the apex court held in this important leading case that such a conduct by the advocate was not a matter between an individual member of the bar and a member of the judicial service. The duty of preserving the dignity and prestige of the courts and of keeping the stream of justice clear and pure lies not only on the lawyers but also on the court themselves. In the important leading case, Muhammad Safi versus Qadir Baksh in 1949, the Lahore High Court held that an abuse to a witness by a judge and intimidation of a lawyer is contempt of court, as it would seriously interfere with the administration of justice. It was also held that if the parties to the litigation feel that they would likely to be subjected to insulting behavior at the hands of the presiding officer of the court, it shakes the confidence in the administration of justice and would pollute the stream of justice. As far as bench is concerned, all judges and judicial officers, starting from the lowest court to the apex court, come within the definition and meaning of bench. Judicial officers of tribunals and bodies established under statutes also come within the meaning of bench. The judges of the lowest civil and criminal courts in the country and the judges of high courts and supreme court are coming within the meaning of bench. In administration of justice, besides the bar, the bench plays the pivotal role to meet the aspiration of the millions of poor and aggrieved litigants to achieve the conditions of justice in society. It is rightly said that if judiciary is a temple, the judges are gods, the attorneys and advocates are the priests and the rituals, and customs, or the acts and rules to be followed in delivery of justice. To the litigants who are otherwise are the devotees or worshippers. So the requirement is a relationship of mutual trust and respect to each other's dominions of power and responsibilities. It shall have to function within the sphere of its limitations, the violation of which will bring antagonism and conflict between the two, and an unhealthy situation would be the outcome. In such an atmosphere, the administration of justice would not be possible, and to achieve the conditions of justice would remain as a dream. It is the dual responsibility of both the create and maintain such conducive atmosphere for furthering the aims of justice to uphold the true values and norms as judiciary is called as temple of justice. Justice delayed is justice denied, or faulty justice is injustice undone. To check the above trend, a committed and dedicated war as well as bench is the need of the hour. So it should be conscious not only of its rights, also of its duties and responsibilities. To achieve an healthy and conducive atmosphere in administration of justice, certain professional ethics and manners are being formulated by the Bar Council of India under its general rule-making powers as per the provisions of Advocates Act 1961. While the Act laid stress on the rights of attorneys and by advocates, the rules carved out the duties to be followed by them. Among the duties as laid down under Rule 1 to Rule 52 of Part 6 of the Bar Council of India rules, duty to court is otherwise similar to the duties of the bar towards the court in its collective and also in its individual capacity. Violation of these duties in individual capacity will draw the provisions of Part 7 under the heading punishment for breach, but in its collective capacity it not only discredit the community of legal professionals, also undermined and defamed the institution of judiciary and administration of justice. Likewise, the bench should be conscious and vigilant about its duties and responsibilities. No doubt the bench occupies a most sacred and honorable position in administration of justice, but it should always follow a respectful, dignified, and impartial attitude towards the bar. Show mutual respect and consciousness of each other's limitations at the necessary conditions for a cordial bench and bar relationship. Bar in its individual and collective capacity bears certain responsibilities for proper administration of justice. As the members of the bar are the officers of the court, so they should follow the basic canons of legal ethics to uphold and maintain the sanctity of judiciary. The bar as a whole shall look after the following duties. How is observed and to what extent? No doubt. It is the individual duty of every attorney and advocate to strictly follow this under mentioned duties, but the bar as a collective body should be vigilant about this. Their proper observation and fulfillment, and these duties are It is the responsibility of the bar and its members, the attorneys and advocates, shall observe the rules framed regarding the form of dresses and robes to be worn in different courts under Chapter 4 of Part 6 of Bar Council of India rules. These dresses shall be sober and dignified. And secondly, it is the duty of the bar to educate its members that they shall maintain respectful attitude towards the court while conducting themselves with dignity and self-respect. And thirdly, the bar must guide its members that they shall not have any private communication with the bench and should not influence the decision of the bench. And fourthly, it is the duty of the bar to ensure its members to prevent and restrain their clients from resorting to any unfair practices or improper conduct. Fifthly, it is the responsibility of the bar to restrain its members not to plead, act, or appear in any way before a bench if the sole or any member thereof related to the advocate. And sixthly, it is the duty of the bar to restrict its attorneys and advocates in appearance if he is a member of the executive committee of any organization, institution, society, or corporation, for or against such organization in or before any bench. And the seventh duty, the bar should guide its members in such a manner that they should make accurate statements of facts and should not twist them. During presentation of their case, they are under obligation to be absolutely fair and should not misguide the court. And finally, it is highly responsibility on the part of the bar to check that an advocate stands not side over rule decisions or revealed statutes. So it is the duty of the bar as a collective body and at its individual capacity to uphold the dignity and decorum of the bench and must observe the basic canons of legal ethics to preserve and protect the sanctity of judiciary, and so also in administration of justice, as the bar has certain responsibilities and duties, so also the bench bears an equally important role to realize the basic tenets of rule of law. The bench plays a more responsible role for a just and equal society. The bench or the judges otherwise should not become prey to the evils of favoritism, nepotism, corruption, and partiality. The judges should discharge their duties without fear or favor, affection, or ill will. They should cultivate the qualities of patience, calmness, and impartiality. They should not resort to formation of any personal opinion on a case and should give full opportunity to the attorneys to present their points. They should always remain above all controversies and influences. They should try to control their irritability and position, passion, While administering justice, briefly we can mention the duties of the judges as follows. And among those duties of the judges, first the bench or the judges should always hear patiently to the presentation by the lawyers with a respective mood, and that very receptive mood. It otherwise means they should give full opportunities to the parties while hearing any case. Secondly, the bench shall have a respectful attitude towards the bar. They should openly recognize and admit the privileges enjoyed by the bar. Thirdly, the bench should deal with the bar with utmost courtesy. Otherwise, the bench in its addressing and dealing with the bar should follow a dignified and respectable manner, because bar is the ground from where future recruitment of the bench is done. And lastly, it is the duty of the bench to avoid interruption of the attorneys or advocates in their arguments in the examination of witnesses. So the bench should restrict itself to undue interference and should avoid a controversial manner or tone while addressing the advocates or litigants or witnesses. Otherwise fair trial, proper presentation of the case or the ascertainment of truth shall not be possible. So a cordial relationship between the two requests, it should respect the other's rights and should be conscious of its own duties and obligations. The canons of professional ethics should be strictly followed by the bar, and it is the sacred duty of the bench to observe and maintain the above discussed duties for proper administration of justice. So, to realize the fundamental principles of rule of law, both the bar and bench have equal responsibility. Judges are not able to defend themselves in public, and so they need the support of the bar. True judges are clothed with the power of contempt, which even the highest executive does not possess. But the power of contempt alone cannot defend the dignity and honor of the institution of judiciary. It is the duty of all concerned, including the judges themselves, to keep the image of an independent and incorruptible judiciary. The bar being an integral part of the administration of justice has a duty to see that there is no unjust attack from any quarter to the institution of judiciary, and it may well be within the rights of the bar to bring to the notice of higher authorities in a proper and inappropriate manner if there is any transgression by any member of the judiciary from the established norms. The bar should show due respect to the bench. However, such showing respect can never be an one-way traffic. The bench has also the reciprocal duty to show proper respect to the bar. The smooth and unhindered administration of justice is possible in an atmosphere of mutual respect of the bar and the bench. The judges are recruited from the bar, and so a judge should not forget that he was once a member of the bar. A member of the bar should not forget that someday he or some other colleague of his may go to the bench. In a sense, the bar and the bench belong to the same fraternity. And if this fact is remembered, there should be little scope for any confrontation or hitch between the two wings of the same fraternity. Happily in India, in relation between the bar and the bench, as between an large cordials have some occasional irritants, though many of them are avoidable. So, in this lecture, almost we have discussed the introductory analysis relating to bar and bench relations and the very responsibilities of the members of bar and also the responsibilities of the bench. And in our next upcoming lecture, we would like to discuss the second part in relation to bar and bench relation, and that is cooperative interaction between lawyers and judges.